She had good intention, but she messed up her case. She had goodwill, still she messed up her own case. In this video, we are going to be talking about mistakes to avoid. Mistakes to avoid when you file your I-130 petition, when you file your I-485 while you're still in removal, when you file I-290B, notice of appeal or motion, basically when you're trying to appeal a decision from USCIS. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. We're talking about TikTok, Facebook group and Facebook page, Instagram, and also here on YouTube. Let's get right into the subject. I-130, mistake to avoid. That's the first case study. She came to us really after she already messed up her I-130. Basically, what happened is the petitioner messed up the I-130 because the petitioner failed to notify USCIS where the immigrant visa will be issued. If the beneficiary is in the US, we suggest that you go with adjustment of status. Why? Because qualifying relative enter with B1/B2 visa, even though the person in question accrue unlawful presence. Because they are adjusting on the family base, qualifying relative, okay, unlawful presence, work without authorization is forgiven. That's why you rather just adjust status in the US, and you clearly indicate that to USCIS on the I-130 petition that's how you're gonna do it. If you know that you're gonna go through consular processing, okay, like you're gonna go out to adjust status, well, you should notify that too on I-130. You notify USCIS. That's when you choose consular processing. You give the address of the consulate and exactly where the interview will take place, right? That question is on the I-130 petition for alien relative. In our case, our client really clearly did not understand that question. She went ahead and pretty much chose consular processing, while the case was referred to NVC for consular processing. And they went ahead and started processing that case, like completing the application and sending all the paperwork through the NVC portal online. Big mistake, because the client is physically here. She never obtained pretty much the waiver of unlawful presence. In other words, if she chooses to go out, she can still go out. But before you go, you have to have that waiver of unlawful presence, I-601A, granted. Especially the fact that you have accrued unlawful presence, which was her case. Okay? So she never did that. But she claimed in her I-130 petition that she will adjust status outside of the US. Guess what? Now they're calling her for the interview, but she's here. She can't leave. So how can you fix that mistake? Well, you can still fix it by filing the form I-824, action on an approved petition, and send it to USCIS along with your green card, now telling USCIS to tell NVC to send the case back to USCIS because the beneficiary in question is here. Clearly they made a mistake on the I-130 petition and they're trying to adjust status in the US. But this mistake will cause you delay and fees. USCIS fees for the form I-824, USCIS fees for I-485, and attorney fees as well. Delay is the big one here, right? The fees, you can come up with money, you can work to job, you name it. But delays, you cannot overcome that. Currently, processing time for family-based in Baltimore is actually 24 months. Last week it was almost 47 months. I'm just glad to see today it went back to the normal 24 months, which is basically 2 years. So this person, this beneficiary that started the process in 2019, at this point, she was pretty much ready to get her green card. It's like now we're starting over. This is a mistake to avoid. Just avoid those type of mistake. Immigration is tough. It has nuances. You need specialized knowledge. Not everybody can do it. It seems like people think that they might be able to do it. Then guess what? They go, they do it, they mess up the case, and now what are you gonna do? Start over. I mean, if a lawyer mess up your case, you have gone to sue them, right? And get compensated for emotional distress, fees, and all that. But if it's your own, you pay for your own mistake. So, well, let's move on to I-485, mistake to avoid. When you are in removal, the general rule is you cannot file I-485 with USCIS. And everybody get this confused. Everybody get this confused. Why? Because we rely sometimes on exceptions, because we know some exceptions, but sometimes we rely on just our own personal knowledge. If a person is in removal proceedings, meaning that they have the order of removal, or they have been granted withholding of removal, or they have stay of removal, or with supervision, something around those lines. It just means that you are in removal proceedings. The general rule says that USCIS has jurisdiction over your I-485. However, you cannot file the I-485. USCIS has, let me go back. USCIS has jurisdiction over your I-485 petition. However, you cannot file the I-485 petition with USCIS until you go back, reopen your case, terminate removal proceedings, or get your case dismissed, then get that order of dismissal or that order of termination of removal proceedings with your petition I-485, then go to USCIS to adjust status. Otherwise, what's going to happen is either they're going to deny your case, which is bad because now you lose USCIS fees of the I-485 petition and attorney's fees, or they're going to administratively close the case, which is good in some cases because at least give you some time to go back to the court and terminate removal proceedings, right? You open the case, terminate removal proceedings, then you can go back to USCIS, reopen your case that was administratively closed and continue. But if the case stay longer administratively closed with USCIS, sometimes, not all the time, sometimes USCIS will ask that you pay again, okay, the I-485 USCIS fees. Just avoid it. Just do it the right way. If the exception is kind of shaky, don't go with the exception. Okay, we've done some exception, we're able to do it, but some exception we are not able to do it. I mean, to convince USCIS. So the best way is to just go straight to the court, okay? Lastly, mistake to avoid when you're trying to appeal a USCIS decision. This is debatable, okay? But from my perspective, what I'm gonna say is this. When the USCIS they pretty much deny your petition, sometimes they give you two options. Option number one is to file EOIR-29, or option number two is to file I-290B, notice of motion or appeal. Choose the latter. Choose I-290B. Why? Because you can track that one easily. The reason why you're choosing this option I-290B is because you already know that you can appeal based on, if you want to open, it's based on new facts. If you want them to reconsider, it's based on mistake of law. You already know the standard, and you can track this easily. Once you file, they'll send you a receipt notice. You can call them, you track it easily. And their processing time for those are really doable, like reasonable. But if you file EOIR-29, your case will go to BIA, Board of Immigration Appeals. Oh, you don't want that, because guess what? Cases have been pending at the BIA since 2018. I have a client where the case was pending since 2018. Guess what? We just had to start over. And we got that I-130 petition granted while the appeal is still pending with EOIR, basically BIA. So yeah, don't follow that path unless that's the only option, okay? When it comes to USCIS denying a decision, pretty much coming with a decision denying a petition. So yeah, those are those 3 mistakes to avoid. 3 different case studies. Well, if you need a consultation, you know what to do. Click the link in the description box. Try not to do it yourself, because sometimes this immigration thing is really tricky, right? Try not to do it yourself. Try to find someone, even if it's not me, you can find somebody else who's qualified, right? At least the burden will be shared if something goes wrong, in terms of, well, if they really mess up and it has prejudiced you, then you have ground for a lawsuit for ineffective assistance of counsel. At least you can get your money back. But if you do it on your own, you lose time, you lose money, you lose everything, and your peace of mind. Well, this is it for today. Happy weekend, everybody. I'll see you next time. We are going to be live in April. I promise we will talk in detail. As a matter of fact, I am putting together a top webinar on motions to reopen. We're going to help some individuals, hopefully, to reopen their case with BIA or immigration court, and hopefully adjust their status so that they can reunite with their family. Until next time, bye-bye.